In this video, we will discuss when courts apply intermediate scrutiny. Intermediate scrutiny is one of the tests that courts apply to determine whether a law is constitutional or not. There are other tests such as the strict scrutiny test, which is the hardest test for the government, and the rational basis test, which is the easiest test for the government. Intermediate scrutiny is a less difficult test for the government than the strict scrutiny test, but it's still a more challenging test than the rational basis test. One situation where courts may apply intermediate scrutiny is where a law discriminates based on gender. A law which applies differently depending on whether a person is male or female may be subject to intermediate scrutiny. Intermediate scrutiny might also apply if a law prohibits speech generally at a time and place. For example, let's say the government passes a law prohibiting demonstrations in a park after 10 p.m. This law applies to everyone at the park regardless of the topic or the content of their speech. A court will probably apply intermediate scrutiny to determine whether the law is constitutional because the law applies to all types of speech. If the law only applied to demonstrations against the government, then it might be subject to strict scrutiny. When judges apply intermediate scrutiny to laws interfering with free speech, they typically ask two questions. First, does the law have an important government purpose? And second, do people have alternative opportunities to express their opinions? For example, if everyone can demonstrate before 10 p.m., a law prohibiting demonstrations after 10 p.m. might be constitutional. To discuss further, please visit my website and blog, and feel free to submit your comments below and to send me an email.